So welcome all. This is Shannon Guernsey with Minnesota NARO, and thank you for being here. Happy Monday, everyone. I'm excited. This is a follow-up. Brandon was gracious enough to do a couple of sessions focused on the new frontiers in regards to the landlord-tenant laws passed this year in Minnesota at the legislature. There was a lot in there. And so the idea was brought forward to have him basically host another one. It's combined. So this is going to be combined both for HCV and public housing, but really for the housing authorities, because we recognize not everybody was able to attend the conference, or you were at the conference and you attended another session, and because we had so many good ones going on. So this is another chance to kind of another bite at the apple, shall we say. And appreciate, Brandon, your sharing your perspective and expertise with our groups. We know that this is an evolving area. I also want to let folks know that I'm going to just kind of jump in there. There are a lot of areas in here, I think, that you'll have really good questions, but there are not answers to them yet, because I don't even think that the judges or folks have even figured out how some of this language and these new statutes will play out. So just want to say on behalf of knowing that Brandon will have to say that at some point, I'm sure today, that it's not his problem. It's basically a problem of just timing. And there's a lot to be sorted and tested and language to be worked out. And things have to work their way through the judicial system. And that obviously takes some time. So appreciate your understanding that from the get-go. That being said, Brandon has a lot of great insights and experience to share with us already. So with that, I will hand it over. I know, Brandon, you also do a bit of an introduction of yourself, so I'll leave that to you. But thanks again, and go at it.
All right, wonderful. Well, thank you everybody for coming. If I lose my connection or become choppy, feel free to put a message in chat, and hopefully I'll catch it that I need to back up and restate something. So please don't be shy to let me know that we've had a technological breakdown. So this is the legislative update for 2023, presented by myself. So who am I? I'm general counsel to the Duluth Housing Authority. So I do an overwhelming majority of their legal work. We do have outside counsel. We'll handle a couple of things that we will pawn off their specialty items. On top of my full-time job as the attorney for the Duluth Housing Authority, I'm also an adjunct professor where I teach things like judicial process, civil procedure, constitutional law, and I'm a board member for the 11th District Bar Association here in Duluth that covers kind of the southern part of St. Louis County and some of our neighboring counties. So that's who I am, and I'd like to disclose that because it's important to have some idea of who you're talking to when you're talking with the law. Some people have some pretty unfounded opinions on how the law should operate. And so I try to make sure that, I'm talking about areas that I have direct experience in and expertise in dealing with. And it's always good to just know who you're talking to see if they're worth listening to on their opinions on the state of the law. So just a very quick disclaimer. So I'm a lawyer, obviously, but I'm not your lawyer. And so if you have individualized questions about how the law is going to fit your facts that you're seeing in front of you, that's calling for a legal opinion. I can't give you that. That's the one step I can't make. But what I can do is I can walk through the state of the law, what the legislature has done or is trying to do, and to tell you some general legal principles that exist universally. And then you can either apply that to your own facts or to seek an attorney out to apply that to your facts for you. Just as a general disclaimer, what I'm talking about here today is not an indication of my client's position. This is my position as an independent legal practitioner on what the state of the law is currently, as far as I can discern, but nothing here is a policy preference of the Housing Authority. This is for your general education. And so if you need individualized legal help, I implore you to turn to a trusted attorney of your choice. So just to kind of set the stage in terms of the changes we've seen, or monumental, to say the least. They're monumental changes in the law. And to understand why that's occurred, you have to understand where we were. So 2021, Minnesota was the only state in the union with a divided legislature, right? The Senate was controlled by the Republicans, and then the House was controlled by the Democrats. Relatively slim-ish majorities either way. 2022, in that election cycle, we pick up an additional seat in the Senate, and it flips control. It's a trifecta of elected power in Minnesota for the Democrats, and they hit the ground, not running, but just a full-on dead sprint. with a one-seat majority in the Senate, they just book it to what they want to produce results that their caucus wanted to do. And it's really an incredible feat to have such a slim majority pass such monumental pieces of legislation. So this is, I guess, a testament to how well someone who's organized can operate government if they can get their people in order. And they pass legislation very quickly, and there's more to come. So just some examples of what we've seen and what's coming in the future that's already been passed. So in effect now, Minnesota non-compete agreements, generally inoperable. If you have a non-compete in a contract, that's probably dead. Other non-landlord tenant examples, additional protections for people who are pregnant, for employees who are pregnant. Restrictions on employer meetings. We saw a big rise in COVID where employers would sit down their employees for a religious or political sermon for whatever reasons the employer had for doing it. Minnesota says you can't do that anymore, right? If you're gonna compel people to be at work, they should be doing the trade that they're paid to do. They really put limits on what you can do with your captive audience under threat of firing them. The legalization of marijuana. Future things are coming down the pipe. Safe and sick time at the state level coming down at the turn of the year, different from the paid family medical leave. So separate piece of legislation. People kind of are conflating those two things. They're two separate pieces. One's going to affect now, and the larger state system is going to tick in 2026. We saw a future ban coming up here on asking past compensation questions when you're interviewing people to see how low you can try to, as you negotiate a wage for people who aren't going into a pay scale. And then you've also seen a tagging of OSHA fines running into inflation. They thought, oh, inflation's eating away the penalty of being non-compliant with OSHA. And so suddenly you're going to have that tagged. The rate of inflation will no longer whittle away how much you're paying for your work safety violations. Going back to landlord-tenant law, which is really the crux of what we're talking about here, this is a growing trend towards tenant protections in Minnesota. And it's only the beginning. So this last year was really a fiscal policy setting session. And as we go into the next year here, we're going to see much more of a broader policy untethered from the fiscal angle. And so this is the base, right? This is what they were able to accomplish in the budgetary session. And as we get into more of a straight policy analysis or policy session, expect more of this. This is your base. And so this is going to be a portent, a window, a glimpse as of what is to come. And so the new session kicks off, I think it's February 12th, 2024. Don't quote me on that, but I'm pretty sure I have that pegged as the right date as when they go back to session to continue the people's work. So we have three broad categories of things that we're talking about. One, you have changing lease requirements. We have changing procedural processes and additional limitations on landlords. And as I talk about this, I do not intend to pass judgment on whether or not it is wise policy or good policy. This is what it is. And people are entitled to their own reaction to it, whether it is net benefit or net harm in the world of housing or for particular landlords, particular tenants. But this is just the changing landscape that we are standing on, because we haven't seen it shift like this in many, many, many decades. Minnesota has a very old, tenant landlord regime, And we've seen, I mean, this is essentially an earthquake in terms of how people are used to having these contractual relationships work. So first and foremost, let's talk about lease changes. So changes in residential leasing. So first and foremost, Minnesota has passed a new prohibition on sneaking fees, and sneaking is, I think, the way the legislature is thinking about this, sneaking fees into the lease agreement. And so on your first page of the lease agreement, you have to display your total monthly payment. And what that means in the statutory language is saying non-optional fees plus rent. And you have to disclose whether or not utility costs are a part of that rental calculation there. This requirement applies to advertisements. So you will want to be very mindful if you do advertising for units that you are including this information, because I would be shocked if there will not be what we call testers in the law, right? Testers is basically people who go out and they're testing for compliance. You see this very commonly in ADA cases where, you know, someone will go to a website or go to location. They don't really have an intention of using the facility, but they're just seeing, is it compliant with the ADA? You may say that, you may see that same testing regime here, because if you are putting up an advertisement, it's very easy to see if it's not compliant. If you're non-compliant, they're going to haul you into court and say, Judge, the statute says they have to disclose this, and they haven't disclosed it. So they need to pay me now. They need to pay me because I've had to sue them for their non-compliance with the statute because they did not advertise it correctly. So be mindful that you're going to have people who are seeking to enforce these provisions. This is not nothing. This is work that we need to do as housers to be compliant. What are non-optional fees? Nobody knows. That's very unfortunate. I was in Minneapolis earlier this spring talking to a number of judges and lawyers on this question, and in this room, and we had a solid number of people in the room, and nobody could really tell anybody what really it meant by non-optional fees. The general consensus of the practitioners there, and this is a wide berth of people in housing, was that, okay, pets probably are optional, not talking about ESAs, not talking about service animals, traditional pets. Those are probably optional. You don't have to have a pet. Parking's probably optional, right? Unless you are required to pay for a spot. If you can opt out of it, probably optional. If there's a gym that you can choose to not have access to, right? You can choose not to access the gym, and therefore you don't pay for that service. That's probably optional. Things that aren't optional, if your facility had a pool and there was a pool fee that was assessed every month or on some basis continuously, regardless of your use of the pool, that's probably non-optional, right? Can you opt out of it? And can you avoid that fee? If it's non-optional, it needs to be included in that total monthly payment calculation on your first page. If you try to sneak it in to where your rent is this, but then somewhere else there's extra fees that are not optional, then you're in trouble. This is not necessarily talking about damage, right? So it's not that, oh, your pet, urinated in the floor, and so we charge a fee for the urination, right? That's not what we're talking about. This is the reoccurring automatic things that you are paying regardless of your conduct. I think that seems to be the intent of the legislature here. So I wouldn't fret about your damages or compensation for acts or things the tenants or their guests are doing. That's not really what we're talking about in this non-optional fee calculation. These required disclosures, this is effective January 1st, 2024. And if you if you screwed this up, you have what's called treble damages. It's something that keeps lawyers up at night. Treble damages in the law, it means that you're going to be paying 3 times the amount of actual economic damage that you're being sued for. So so that might be 3 times the amount of the fees that you were charging. Heaven forbid you were charging it for a long period of time, because you're going to be paying that times 3 back to the person. And then the real kicker is opposing attorney fees. The traditional American rule is everyone pays their own lawyer, unless And the unless is unless the statute provides for fee shifting, where it says, no, not everyone's paying for their own lawyer. You, landlord in this case, you've lost. You're going to pay for this tenant's attorney. And that really, really motivates private attorneys to take cases because they say, oh, this tenant doesn't have any money. Right? Average private practice, someone comes in the door, and unfortunately, it's about keeping the lights on. And they come in and they say, oh, I have a claim against my landlord. They didn't acknowledge that I was paying $5 a month as some sort of a convenience fee or to have an extra fob I was paying on a continuous basis, whatever it happens to be, something that was maybe not entirely optional. And I've been paying that for 3 months now. And the statute says you can't. Well, as the private attorney, you take that case and you say, well, there's no money here, right? I needed a $5,000 retainer up front to start the work. And you'll never recoup that. So the dollars and cents will not add up to your case. But the attorney takes that case and there's a fee shifting provision. They say, you know what? You don't have any money and your claim is not worth really anything. But if I win, the other side's paying me. And that landlord or that housing authority, they got money. They have a budget. They have assets. I can lean that up. And if they don't pay it, I'll try to sell it. And so they know that there's blood in the water, right? And so it motivates attorneys to take cases like nothing else. So when you see a statute that has this fee shifting for opposing attorney's fees, private attorneys, they are jazzed. They love it. Because it's money they will get paid when they win, especially if they're litigating against the government, because the government's going to have to pay it. There's no chance that a housing authority is going to be able to resist a lawful judgment. The judge is going to compel that payment, and the public boards are going to be unable to to hide from that judgment. So here's a live action shot of lawyers taking your budget. As I said, I've done private practice work. It's a lot of fun to win. It's a lot of fun to win against people who have to pay you. Because many times you will have people who you sue out who can't pay you. And then it's just paper that's worthless. But when you have a defendant who's going to pay, that's where the sweet spot is. We have other new limitations. Limitations on declawing and removing of the vocal cords for dogs. So no longer in Minnesota, your lease cannot require declawing or devocalization of pets. For those who don't know what declawing looks like, and this is a moralistic stance that the legislature's taken, so we don't like declawing because it involves the dismemberment of a bone from the claw of the cat. I put up your little image here of what the claw looks like and then what it looks like when it's been removed. It's actually akin to, if you look at your hand and if you look at your first knuckle, if you amputate that first knuckle off, that is the net effect of a declawing for a cat. So Minnesota has decided for itself that's inhumane in the eyes of the legislature, and you can no longer require that as a landlord. So if that's in your leases, you would, maybe be wise to consider removing that material before someone says, look, they're trying to get me to declaw my cat in violation of the law, even if you don't intend to enforce it. And a lot of this stuff might be tucked into very old lease agreements that don't really get updated. Many practitioners in the real estate world have leases that are the product of time. And so, maybe 20 years ago, there was a clause about declawing cat that's always just kind of snuck its way into every iteration. It wasn't a problem to remove. So you really have to go back and do that digging to say, look, what's our really old stuff in here look like? And does that comport with the changes we're seeing? Because if not, we might be in trouble, even if we're not enforcing it, right? Just it's on paper might be enough to get you in trouble. So that goes into effect January 1st. Your penalty for having this impermissible clause in your lease agreement. Well, penalty primarily enforced by the Attorney General's office, it's the AG office, the county attorney, the city attorney's office. That's who's kind of vested with the prosecution of these cases. So, a sophisticated operation to be prosecuted by. The penalties are $1,000 per advertisement. And it's not entirely clear whether or not this issue has to be specifically advertised as, to deter people from applying, but it indicates per advertisement and per animal that it occurs to. And there's this undisclosed mystery box of pain attached to the statute. And there's some language in there that says, and other penalties as defined by law. Not entirely clear what that section's pointing to, but apparently the legislature was contemplating some additional penalties that they would put you under for violating the section. And for those of us who, one, maybe don't even enforce clauses like this, let alone know it's in the lease in the first place, it might be best to simply not open the undisclosed mystery box of pain for an issue that you may not care about. State mandated unit inspections. More inspections are coming to Minnesota, mandated by the legislature. So this is born out of MnStat 504B.182, Section 1. You have to do initial unit inspection. This is new. So at commencement of the lease, so when they start the lease, or within 14 days of the commencement of that lease, the landlord must notify the resident of their right to inspect the unit for deficiencies to avoid a deduction against their deposit. Now, this is a real change for most people because most leases have something like within 2 days of taking the lease, you can tell us about defects. And if you don't, you say that it's great. That language does not seem to work anymore, right? They have a right to inspect. They have a right to do a walkthrough with you within 14 days. And so it's not clear that you can shorten that window. You might be stuck with that 14-day window if that's the timeline that works for their schedule. Because the inspection has to occur at a mutually agreeable time. And so if they say, look, I can't meet with you to inspect, I want an inspection, but I can only do it in 14 days from now, well, that's their right. That's their statutory right under the law. And you're stuck with honoring that, even if it may be burdensome to you, or if you're concerned that they might, possibly damage the property before you get the inspection done. It creates additional risk for the landlord. If the tenant agrees and you're agreeable to it, you can do a photo or video log of the property instead of inspection. And so you can provide the acknowledgement in writing saying that, yep, we're both agreeing to this. And here's the video or photos that are going to encapsulate what the property looked like in lieu of inspection. So there is an alternative. If the inspection timeline doesn't work out, or the tenant doesn't really care a whole lot, you can just kind of quickly do a video walkthrough of the property. And the tenant can do this walkthrough themselves if need be, and provide that to you. And then you provide them some written acknowledgement that you're accepting that as the condition. But you can't enforce this without their consent, right? If someone says, I want a walkthrough, and you say, we do video walkthroughs only, take a picture, you can't force that on them. They have a right to an actual walkthrough with a person if that's what they want to do. Move out inspections, still a thing, right? So you have move in, you have move out. This is taking it to a reasonable time of the notification that the lease is going to end, but has to occur before the lease is actually over. Sorry, the tickle in my throat here. You have to notify them of their right to do a move-out inspection and their right to attend. So that is something you want to make sure you paper your files with. You don't want someone coming back later and saying, hey, you never sent me a letter saying that I could do a walkthrough or that I could be present at the walkthrough as I moved out. So please be mindful of those, eventual disputes that you will have at some point in time under this regime. Your move-out inspection. So you have to have it. You have to have a move-out inspection. There's really no way around that one. But you can't have it earlier than 5 days before the termination's up or the end of the lease. So you can't do a move-out inspection a month early, right? It has to be kind of contemporaneous with the ending of the lease agreement itself. Or the day the tenant actually moves out. You could do the inspection the day they're surrendering the property. And then Shannon, just let me know if we have any questions that are tucked away. I can't see the thing, so please
Yeah.
let me know.
That's okay. I will have a question for you maybe before just the crime-free leasing slide. So let's stop for that.
Sure.
Perfect.
Wonderful. Right. And then again, this is tagged to a mutually agreeable date and time for these inspections. I know that many housers are not particularly jazzed about that language. It's tough. You may have people who say, look, I'm only available on the weekends. I don't think necessarily you're compelled to pay people overtime to accommodate that necessarily. You probably are going to be safe-ish of doing it in traditional business hours. And it would be kind of a stretch thing for courts to punish people for not being available at 3 a.m. on Christmas Eve to do a move out inspection, right? If that was the only thing that your tenant gave you as an option. But it certainly creates some uncertainty in the law and what your requirements are. The idea behind this statute, of course, is to identify damage done to the unit, right? That's the whole purpose of move out inspections. And it further contemplates them repairing the property if the lease allows them to avoid a loss of the security deposit. I do not know of many lease agreements that allow the tenant to do the repairs. I think that is uncommon. This does not compel a landlord to let someone make repairs. That's not what it's compelling. But the theory behind it is establish these inspections, and if the landlord's okay with it, let them fix it. So if your lease allows them to repair, they can repair. If your lease says you don't do repairs, we do repairs, we bill you, then it's just a deduction against their deposit. And it's probably a dispute as to whether or not they caused the damage or not, or if that was something that was pre-existing. Or was traditional wear and tear not subject to withholding? I guess is probably your second option on that one. All right, initial inspection and move out inspection. The changes to the inspection statutes go live January 1st, 2024. Penalty, the loss of your security deposit. So if you aren't doing your inspections appropriately, I think you're on the hook to lose your security deposit. You'll pay that back to them, even though you may be out money. And you can't, and potentially more, there may be other creative damages imposed on you if you fail to do these inspections appropriately. And you cannot require a tenant to waive them. You can't put in your lease agreement saying, we don't want 14 days to inspect in a move-in. We want 2 days. Waiver is contrary to public policy. It is void. That's specifically in the statute. They say you cannot waive these provisions. This is the law. This is what you must do, regardless of what you want. So we're going to be talking about crime-free leasing provisions. I'll see if Shannon wants to ask a question now or later.
Yeah. So a question I have for you, again, folks are probably, taking notes furiously, thinking about the leases that they have. I think this is particularly. So a pragmatic question is, if you have a lease with a person, does this only apply to leases that are signed going forward as of the effective date, or does this affect all leases that are currently in existence with, so if they were signed their lease last year, is this applied? And then I think that my second question would be, in light of your answer to that, what do you recommend as a best practice? Of course, there's looking at the lease and looking at these terms and seeing if there's things that need to change. And then do you suggest that new leases get signed with everybody or not? Thoughts?
Yeah, good question. Let me double check here. I do think that this goes into effect for new leases signed after the date of effective that it goes into effect. Generally speaking, states have a very hard time interfering with the obligations of contracts already entered into. And so I guess I was just kind of looking through materials. I don't recall off the top of my head completely that that's the right answer. That's my hunch answer, that I believe it goes into effect for things that are coming up. As a practical matter, you may choose to say, look, we don't want different leases with different provisions. And so the administrative overhead gets kind of high. And so we just want a clean slate, and we're going to go ahead and just shift everything over. That's a viable answer for people. who don't want to kind of juggle multiple leases with different provisions in them. So I think that is a good business decision or business discussion to be had as to whether or not you absorb the overhead of managing different leases as you phase in a new lease, or if you just clear cut a whole new system, a whole new regime. But this is something that goes into effect for new leases, I believe, and then will trigger for everybody coming forward. Is my immediate question.
Yeah, and I think that's important because I think again, practically, it gives some, in terms of implementation. This is not something that's going to take effect in all your leases as of January 1st. It's again, I agree with you. It's new leases. So they're not this is not interfering with existing contract. That being said, it is the practical question of how many various types of leases do you want to manage? And so there you might an agency might decide upon review of a new lease, so just want to throw that timing and practical implication out there and let people know that they do have some time to implement this going forward, and then they can make that business case of whether they're going to just do all the same lease or not. Thanks.
Yeah, absolutely. And I will reserve the right to have that answer be incorrect.
Right.
So please
Yes.
make sure that you double check with your internal counsel to make sure that's correct. But that's my hunch. Not having the answer directly in front of me here, I do think it's prospective, but you want to make sure to do your own due diligence on that. I'm a lawyer, but I'm not your lawyer.
Yep. And courts can say otherwise.
Yes. So be mindful of that. Yes, and there is a difference in what the law says and what the judge will do. There is a distinct divergence on that many times. So Minnesota has passed new legislation that says, look, we don't want landlords to be de facto prosecutors. We are going to remove from landlords the ability to do this quasi law enforcement function through the operation of their lease, right? They don't have any business terminating housing for crimes unrelated to the property, for crimes occurring off property. And that's what this enactment is doing. And I know that this is the bane of, I think, every houser I've discussed it with, in terms of concerns that they're going to have potential bad actors in their units that they might not be able to get rid of until a conviction comes down. And so that's certainly a burden on those operating that business angle of it. So turning to the statute, Minnesota Statute 504B.171 sub 2A, a residential landlord may not impose a penalty on a residential tenant. So no penalty, you can't penalize them, or you can't terminate the lease of a residential tenant for the conduct of the residential tenant, household member, or guest occurring off the premises or curtilage of the premises unless, right? It's a blanket prohibition saying our court doors are shut to you. You cannot terminate, you cannot evict them, you cannot penalize them for this conduct that happens off premises or off curtilage, unless there's two exceptions. And I expect there'll be questions on this because this is convoluted. Even as an attorney, this is convoluted. Unless number one, exception one, the conduct would constitute a crime of violence against the landlord, the tenant's guest, or another tenant, or a landlord's employees, regardless of whether or not they've been charged or convicted. First exception, right? So if they are committing a crime of violence, if it's domestic violence, for example, in the home, and that's not our tenant, right? That's a crime of violence against another tenant. A guest of the tenant, you or one of your employees, you get to penalize or terminate that lease agreement with them to get out of it, regardless of the conviction status, regardless of whether or not the government charged them in the first place. Prosecutors bring cases and decline to bring cases for all sorts of reasons. You don't need to rely on any of that. If it's a crime of violence, you're out from under this statute. Number two, the conduct results in a conviction of a crime of violence against a person unrelated to the premises, right? Your tenant goes out and, they walk 14 blocks away they gun somebody down the street, first degree murder, they get locked up. Unrelated to the property, not your employees, not a guest, not a tenant. That person is your tenant until they get convicted, and then you can end the lease agreement, right? Because again, it's a conviction. It's a conviction of a crime of violence. And so once you've obtained the conviction, then exception 2 applies and you get to terminate that relationship. They will have been out of the premises in reality. They'll be in jail for the entire proceedings and they probably won't pay for it. And so you could move to evict them for non-payment, but that's for non-payment, not for the fact that they have been charged with first-degree murder. So think about your different options that sit in front of you as to how to play under these rules. If you have a separate prong to operate under, that's not the criminal angle. So crime of violence, for the purpose of the law we're talking about here, a crime of violence is the traditional criminal definition for a crime of violence. There's a list, except for those offenses that are listed in chapter 152. And I know everybody listening to me is deeply familiar and intimate with chapter 152 of the Minnesota Criminal Code. No, you're not, and that's okay. It's drugs. So we have a list of violent crimes that are subject to all sorts of special rules and conditions. And the legislature said, look, yeah, violent crime is bad, but not drugs. No, we want only the real violent crimes for housing. Everybody else gets this, gets the expansive list of violent crime that includes drug offenses. But for housing, only real violent crimes apply. And so you don't get the drug offenses to get out from under this requirement. Examples of crimes of violence: murder, manslaughter, assault, domestic assault, robbery, kidnapping, crim, sex, burglary, drive-by shooting, arson, riot, terroristic threats, harassment, shooting at public transit. So it's a specific list, right? They have a list of criminal cases or criminal codes that trigger this crime of violence. It's not just what you feel is violent. There's a specific list that contains these different statutory citations as to what crimes count as a crime of violence. Reminder that we're talking about crimes committed off premises, right? If it's off premises, off curtilage, and I'll define that in a second, then these prohibitions attach. If it's crimes happening in the unit, you are not subject to these prohibitions, at least under the terminology of the statute as it presents itself. So understand, don't say, oh my God, people are going to be murdering each other in my building and I can't do anything about it. Not quite true, right? But that does mean, so I'm in Duluth, Minnesota. If we have, Pablo Escobar down at the docks and they bust him, with 1 trillion, kilos of coke, greatest drug heist in the history of the known world forever. He's my tenant. He's my tenant through that entire deal, right? This is an off-property crime until we get a conviction, and he's going to be there the entire time. So that's what you're kind of stuck with under these rules specifically. So when talking about this off-property crimes, you have to understand that you can terminate for crimes occurring on the premises. You can terminate for crimes occurring within the curtilage. And I'm going to bet that everybody here who is not a lawyer has maybe never heard the term curtilage before, ever in any other circumstance their entire life. And it's because it really is very much strongly associated in the world of criminal law. Curtilage is the liminal space around a home or around a structure that is kind of the intimate space between the general public and your dwelling. So, right outside your window, right, there's a zone of curtilage. That's a very fuzzy definition to talk about, but it really applies to law enforcement officers, the exercise of the force of the state against people as you're dealing with certain protected areas. and what conduct can they engage in within the curtilage of a home, the liminal space. And so on my screen here, I have a little depiction that hopefully you can see. You have your public space outside of the rectangle. Right? Think of the rectangle as your parcel of land. You have public, you have private, and we're going to use private to say, it could be government property that's not, totally open to the public. So you have some land owned by somebody who's not just like generic, like a public park, right? That's controlled in some way. Within that property, you have the curtilage that surrounds a building. And the statute here does not define how they're using this term. And I think it's going to tee up some litigation because it doesn't really tell you what counts as the premises and doesn't count when it's talking about curtilage, because the premises could be easily understood to be the entire lot of land, right? We have a high-rise building. The premises of the high-rise can be the entire lot. Well, if that's your articulation of premises, that conflicts with the concept of curtilage, because a curtilage is a tighter restriction than the full parcel, right? It's that intimate space around the doors and the windows and the walls of the property. And so it's very unclear as to what we're talking about in terms of crimes off premises. I think, when I undoubtedly have to litigate this at some point in time, my argument's probably going to be that the legislature does not use the term dwelling unit, that if they wanted to confine it to a dwelling unit, they would have said so, because that's what premises seems to be hinting at. If it's premises or curtilage, it would seem that the premises is limited by the terminology of curtilage. And so heaven forbid you get an articulation that in a high-rise building, the crimes that you can result in eviction have to be occurring in the dwelling unit itself, or the curtilage of the dwelling unit, which is maybe the hallway leading to the door. And so maybe your common space isn't protected. That's the most restrictive reading of it. And I think that landlords will probably be successful in saying we need a wider expanse of understanding of premises and curtilage in this domain, that really we should be talking about all common spaces. But that's going to be a fight. People are going to litigate how far from the dwelling unit can you terminate a lease when they're committing crimes to be under the exception. And we simply don't know what that's going to look like. But just know the legislature has kind of put its thumb on the scale and says, look, we don't want landlords evicting for criminal offenses. They're not cops. They're not prosecutors. They should be housing people, and we don't really care how difficult it might be when they're going through criminal prosecution. It's just not your domain to be dealing with. So that's one of the challenging pieces of unclarity we have here in terms of how this is going to operate for the crime-free leasing exception. That goes into effect June 1st, 2024. So there's some time. There's some time before the crime-free leasing provisions kick in. I would encourage people greatly to seek outside counsel or their own attorneys if they happen to have somebody on staff in dealing with the first couple of cases that are going to be these criminal actors, and you have something going on outside of the property that you're trying to end the relationship for, right? This is crimes off premises, off curtilage, where you have your two exceptions to navigate that, because this will be new to you. This will be new, and you don't want to fall flat in your face the first time you try it. And you might if you don't have the right preparation. Any questions on that? I'm going to stop for a minute here just to see if questions, because I know that is a complicated bit.
No, I don't have any questions in the chat yet, so keep going.
Okay, that's okay. All right. Tenant right to privacy. So we have seen the legislature enact a statutory right to privacy for tenants. Essentially, you have to give notice to enter, and that can't be less than 24 hours, but they can let you in sooner, right? So if you're going to go there, for any non-emergency arrangement. So you can still ask the property for an emergency under the prongs that exist. But if you're going to go there, 24-hour notice is the minimum. They have to have at least 24 hours notice. And that your notice has to specify a window of time in which you're going to go there between 8 a.m. and 8 p.m. unless they agree otherwise. In talking to a number of judges and lawyers about this, kind of humming and hawing over, what is a window of time? What even is that? How do you interpret this language? And the suggestion that kind of came out of this, informal committee of people talking about it was about a 4-hour window is probably pretty safe. To say, look, we're going to be there between 8 and noon or 1 and 5. If you give people a 4-hour window, you're pretty safe. I mean, that's a pretty standard window. But you can't. And the judges were saying this. If someone, I don't know what to do to a landlord if they come in and say, look, I told them I'd be there on Wednesday. Wednesday isn't a window of time, right? It's a day of the week. And so you don't want to get hung up on that technicality. If you can narrow it down to give people a window of time before you make entry, and to make sure they have 24-hour notice of that entry. And this is important because in this case, the Minnesota legislature is essentially saying, look, you are a landlord, you're not a cable provider. You can't say we're going to be coming sometime in November to come work on your stuff. You're able to be much more diligent and mindful about your own scheduling and can give them a realistic window when you're going to be there. And of course, you can cancel and not go, right? You're not compelled to go within that time. But if you're going to go, it has to be within the window of time you specified, unless you have their agreement otherwise.
Brandon, so just as a practical follow-up question here.
Yeah.
So great. I know a lot of housing authorities will typically, if they're doing, housing, we're doing this maintenance or this project or whatever on such and such a day. You're saying that probably it would be a good practice to be more specific than just this day, because again, housing authorities are really good already about giving notice about entry. Now you're saying, though, probably need to look at it about, okay, we're going to do a window of time and be more specific. That's what I'm hearing you say.
Yes. I think the statute is explicitly telling landlords, you gotta be more specific. Just saying a day probably doesn't cut it. It's talking about a window of time. I don't think anybody realistically can do the specific time, right? That's not what they're asking for. It's really a window of time. But if you simply stay with the practice of we're going to be there on Wednesday, you probably run the risk of getting somebody who's aggrieved, who's going to say, that's technical noncompliance, right? You are not complying with state law. You should know better. You are sophisticated. There's no excuse for this noncompliance to the statute. And you're probably going to get a judge with the gavel that says, yeah, you could tell them if it's the morning or the afternoon, give them a window of time and you're fine. And so my suggestion of 4 hours is not gospel. This is just a couple of lawyers and judges sitting around saying, what is a window of time? And they thought 4 hours felt supremely safe in terms of a time where you were not going to get smacked around by the legal system for that choice of timing. 6 hours, maybe 8 hours. That's probably a bit of a stretch. That's a pretty long window of time to be not so much a window, but an entire day, right? So you can take on your own personal business risk is what you think is appropriate for the needs of your operation. So maybe 6 hours does work.
So got a couple, follow-up questions on this. So here's a scenario, and it's all around that timing issue. Because again, this is about risk, like you said. In regards to landlord entrance and work orders, I think this calls out to when you have an agreement with the tenant, perhaps. Does this language require you to give 24-hour notice when the tenant has requested a work order, non-emergency? So for example, tenant calls, requests work order to check out a smelly drain. Do you still need to give 24 hours notice? And I think that speaks to a couple different elements of this, practical elements.
That's a great question. So in that case where someone is affirmably putting in a work order to say, come work on my stuff, I think the 24-hour notice period still applies. However, you can fix all of that by having a checkbox that simply says, please come in sooner to fix it if you can. If you get their permission to come in sooner, you can. But if they haven't given you permission, I think the 24-hour notice period still applies unless it's an emergency, right? You can always enter it under an emergency to do emergency repairs, no notice required. You can do that. That still exists. But if you're going to go in for a non-emergency, they get 24-hour notice so they can, be, have showered, have cleaned up a little bit, whatever they need to do, right? It's their privacy that you're invading. That's the legislature's talking about, right? They're saying we are creating a statutory right to privacy. You can invade that privacy by giving this notice. Otherwise, leave them alone. And so if you create a drop-down box or a checkbox or hypothetically a pre-checked box that you can uncheck to opt out of, to say, I don't come within the next 24 hours. You can figure that out on the business angle, how to swing that notice. But I do think you're required to give a notice. And I had a pop-up come here, so I think that someone had messaged me. So I do have another, question to answer. For apartment inspections, do we have to notify each individual person, or can we put up posters and put them in the newsletter? That's a tough one because you're going to be fighting about whether or not somebody got notice. And in my agency's stance and practice has been that we do individual notices to everybody. We'll slide it under doors or whatever have you to make sure that we can say without a doubt that this person was given a slip of paper that says X, Y, and Z. And if they drag us to court over it, I will have a living body who can say on blank date, around blank time, I took this slip and I put it under the door to this house.
Yeah, and I think that makes a really good, that, again, thinking about from the kind of risk you take, how hard would it be to, again, like you said, you put the notice under the door, you can have somebody attest, because this is about taking the risk of what will happen if they decide to challenge you on it. So.
Yeah, but I will say, I don't recall the statute specifying how notice will be delivered, right? Sometimes you will have statutes that say that notice has to be delivered in certain ways. I don't recall off the top of my head if the statute says that. And so if that language is absent, then maybe it is fine to do a newsletter and an email blast and put it on the front door. That might be sufficient if it doesn't specify how notice shall be given. But that comes down to your own risk assessment as to whether or not, is it worth the time savings to not do the individualized letters or whatever your methodology for delivery of that is, versus just your posters. And people can have very valid conclusions either which way as to what works for their business model. So I don't mean to say that's impossible or impermissible. It has its own inherent risks and rewards to it, because you may never get buzzed on it. Maybe you spend the next 30 years and no one ever complains about it. It's a total non-issue.
Right. So here's another, just again, practical kind of, how this operates for people to think about. Question is, sometimes a professional needs to be called in, such as a plumber. How do we determine the time frame for a second party professional, as again, it relates back to notice, entry? Any suggestions around, again, a practical application?
Sure. So yeah, you're talking about calling in a third party with some expertise to do the work because you can't do it in-house. Super common, happens all the time, right? In that case, I would press the professional for a window of time in which the work can be done, right? Assuming non-emergency, right? You don't need them there this second. Can we get something scheduled? And to kind of press your community partners, your contractors to say, hey, we would like to have you do this kind of work for us. Can you give me a window of time on Thursday when you might be there to do it? I need to give them some notice that you're coming in. And this is assuming that the tenant is not willing to waive that 24-hour period. If you get permission by the tenant to come in sooner, then it's a non-issue. And many tenants are very keen to get their stuff fixed. And so when they're calling in a work order, if there's a way for them to give input on that, I suspect many people will choose to check a box or to include something that says, please come in sooner if you can, to just not worry about that. You're going to have people who say, no, thanks. I want you to tell me that you're coming. And those are the case you have to watch out for, because you may run into noncompliance. And so you're still stuck with that 24-hour period, even if it means you're working extra hard with your contractors trying to find a time that works for them.
Yeah. I mean, again, you can't legislate good relations between landlords and tenants all the time. So, but this, I think it does, a lot of this is solved if you're able to have good communication and good rapport with your tenant. I mean, that it solves a lot of these issues. Here's one more, again, another practical question. But it relates back to, again, the lease. What if the lease states that when you're requesting a work order to allow maintenance staff to enter with no time frame? Is that something to consider?
That's a great question. So there's a couple ways to think about that, right? You're gonna come into what's called a fight over waiver, right? You have default rules in the law where the law says, look, when this is the default rules that exist for everybody unless you change them. And sometimes you have rules that can't be altered, where waiver is void, right? Your attempt to waive a rule is void. And I do not believe this statute has language saying that it is void for public policy if you try to waive it. Doesn't mean that a court won't say that, right? A court might say, look, it's a statutory to privacy. How can we possibly waive that? Just out of hand, right there. That should be unwaivable as a practical matter. So even if it's not in there, you can have a court that writes that in there themselves. They can blue pen the law and just kind of add that little bit to it. Now, if it's the only way they can create a work order is to waive this, that's probably dicey. That's a probably dicey way to approach it. I don't know how comfortable I would feel defending that lawsuit. That's assuming you get sued for it in the first place, but you will eventually get somebody who's a stickler for the rules and who's going to say, hey, wait a minute, you're violating my rights. If they have a way to opt into it, I think the argument is infinitely stronger to say, look, you checked the box, you did the thing that told us we'd come in early. Even if it's still a strong argument. I think if the box is pre-checked and you say uncheck this box if you do not want us to give you 24-hour advance notice to come, or however you want to, you can phrase it however you want, that they can opt out of. To say, look, we have a process, judge, where you fill out a work order, and when you do that, there's a box you can uncheck if you want us to give you 24-hour advance notice. That's still a good argument, I think, because then someone physically has to go through the process and see this in some hopefully obvious way that they're opting out of their rights. But a default waiver in the lease agreement, that's probably a tough argument. I can't say it wouldn't work, but I can imagine a number of judges saying, man, you're just trying to rewrite the statute, right? The legislature told you what the rules are, and you're just trying to say no thanks. That's a tough one, a tough argument to make, I think.
Well, that looks like those are the questions we have thus far, but you're right. I think it's putting it in the lease probably creates a bigger risk if it's challenged down the way, as opposed to figuring out a process that works and the work order and such. But again, a lot of this right now is about a risk assessment.
Yes, because we simply do not know how the courts are going to interpret some of this language and its operation, right? We can't turn to 20 years of case law and say, look, this is how everybody else has been doing it, and all the courts said it's fine. Because a lot of this is brand new material, we're not going to know until someone gets smacked, right? It's a game of whack-a-mole, and you don't want to be the mole that gets whacked.
So that's all we've got in terms of questions right now. So yeah, keep going.
Wonderful. As we continue on, so that right to privacy for tenants is effective January 1st, 2024. So right on the horizon. Be mindful. Recovery of fees. So this has been the long-standing rule in Minnesota, right? If your lease agreement says that you can recover attorney's fees, the other side can too. Now they've added to that. If your lease agreement lets you recover your attorney's fees, essentially a fee shifting rule, right? A fee shifting. We get our attorney's fees back. It also adds costs. If your lease agreement says you get costs for filing a lawsuit, they can get costs for defending the suit, right? If they had to pay into the court system to file certain papers to defend themselves, separate from the attorney question. The tenant gets them too. I think it's pretty common for housing authorities in Minnesota to have some provision in their public housing leases or elsewhere that says, look, we get the cost of filing the lawsuit back. We don't get attorney's fees back because it's simply not worth the risk. I think on that front, I think you're capped at $5 in your eviction case to recover your attorney's fees back. But the filing fee, which is generally, what is like $305 for online filing, plus about $65 at a minimum for service through whomever you're using for service. The tenant, if they've had to put costs in to defend themselves, they get that back now automatically, no matter what your lease says. This is a protection for the tenant to say this cuts both ways if you put it in your lease. I suspect that many landlords and housing authorities will keep that language. That for them, they are. I mean, I will use myself as an example. I'm pretty proficient in what I do. I can't recall the last time I lost a housing case. And so for my client, it is infinitely worth it to try to collect these costs for non-payment because we haven't had a history of losing them. And so if we had to pay a couple $100 in a lost case under this fee realignment kind of statute where it says, look, both tenant and landlord get their fees back, whoever wins, for us, it's still probably a massive net benefit to collect the filing fee if we win, knowing that we rarely ever lose. But you may have different risk calculations, and that's fine. You should have your own risk calculations. Do we litigate often? If not, is it worth the risk? Are things that you may want to think about in keeping these clauses or ditching them. That recovery of fees, that goes into effect January 1st, 2024. So just be mindful that's coming right up now as well. Eviction actions. This has been one of the largest areas of change we've had in the law. It is truly monumental. And so to everybody, I wish you all good luck as you move to litigate and navigate these changes. First and foremost, there's a changing to pleading standards, and you're gonna say, I don't know what pleading standards are at all. And that's okay, you don't need to. I'm gonna break it down for you. Long story short, landlords need to be much more specific in their pleadings, AKA their complaints. So when you file an eviction action in Minnesota for an eviction case, you need to be specific to what you're talking about. You gotta, you're attaching your lease and your ledger and a narrative outlining the breach, right? You're gonna be citing to, look, on or about this date, you breached this clause of the lease. Next one, on this date, you breached a different section of the lease by doing X, Y, and Z. The expressed intent of the legislature in this statute was to make it much harder to get in the door. Make landlords put in the legwork in the hopes that they negotiate their claims instead of filing. So you're doing a lot more legwork. It's not going to be good enough to saying you violated your lease for drug possession. That might not be enough anymore, right? You need to spell out, the factual causal nexus between what you think you know and what your lease says. So be mindful that you're going from a notice pleading standard to a fact-based pleading standard for those who are more legally inclined. Changes to these notice standards. It also includes documentation requirements that you tell people they have a right to an attorney in public housing cases. I believe it's located in your complaint. You have to have some specific language that's copied and pasted and done in a certain way. The statute will tell you what font size and all that jazz it has to be in. So tenants have a statutory right to counsel. They have a right to an attorney in public housing cases. What is public housing? You know, I thought there was wider agreement on this in Minnesota than there actually is. I can tell you for the 6th district, so that covers kind of the entire northern Arrowhead region of Minnesota, they have determined, the judges have determined for themselves, that public housing is essentially any kind of housing that has even looked at public money, right? It's not traditional federal public housing that everyone thinks about when it comes to public housing. They're thinking anyone who has state money or local money or federal money of any kind, Section 8, that's a huge one. Possibly TIF districts for housing developments, right? If you've gotten special tax increment financing agreements for your development project, your tenants might be public housing under this statute. It's a huge net. We disagree. We object in every single case and say that's a nonsense reading of the statute. We have not appealed it. It's going to be a huge fight someday for somebody else, hopefully. But they think that everybody gets an attorney who even smells public money in any capacity of any kind. But because that's the interpretation we have in the 6th district, it may be different in your judicial district. Your written notice has to contain certain statutory language. It's going to be in the statute. You'll see it. It says include this language, and you just copy paste that material into your complaint, into your notice. And for non-payment cases, you have to specifically include an accounting for charges and totals, right? It's not going to be good enough to say that, hey, you just owe me blank dollar for rent or blank dollars for maintenance charges. You got to get specific. I think the expressed intent in this case is, look, we think the legislature, and speaking as legislature, we think that the balance of power between renters and housers is uneven and we don't like it. And so we're going to rebalance it. It is not fun to be the person who's being rebalanced upon. I get that. So understand that that is the rationale here. And so it is more work. And you have to do that work if you want to succeed.
Brandon, on the right to counsel, not only, well, I agree. This is an area where, depending on the location of your eviction, is going to really depend on whether the scope of what right to counsel is involved and what public housing is. Because we have other jurisdictions who are saying, if it's just the housing authority, that's the one bringing the eviction. In other cases, they are looking that they recognize that it's just a program within HUD and it's a specific, and they're limiting it to that. I think this is an area that is, again, the broad net of that you're dealing with in your jurisdiction is, well, it is obviously problematic but it is the broadest interpretation of it. And there's most other jurisdictions, it's been a different reading. Also, just to remind folks that, again, preserving that objection is important because it does not involve non-payment of rent cases. This is breach cases, which is also an important clarification. I think if you can talk to that a little bit as well.
Yes, absolutely. Yep. So when you're doing these breach cases, a breach of the lease for something other than non-payment, you're going to get, this appointment of counsel. I think the rationale behind it is that the non-payment cases are so self-explanatory that it's a different kind of creature to deal with in terms of where is it worth appointing independent counsel to fight this case. So continuing on then here, what happens if you
I'm sorry to jump in on it. I would say, though, to call out, if people are confused by this and that the language that you need to put into your eviction action looks broader and different than actually what the statute says, I think that's a fair place to be confused, because I think there's a disconnect there too. The language that you have to include looks a lot broader than what you actually get or should get under, at least my interpretation of what you should get under the statute. So that I understand that it's confusing.
Yes, and I can't recall if it's later in the slides or not, but I'll just share it here just in case. When you're talking about some of your other notices and stuff, you're going to see material that says you have to put language in that talks about 14 days and 14 days and all these different timelines. And you're going to say to yourself, I don't operate on these timelines. Right? I'm under the CARES Act. I use 30 days. The last line of that's going to be like, and government entities may have different time periods, and you're that exception. And so it's going to confuse the heck out of your people. It will. It's going to be highly confusing to them. And that's just, when you have what's called statutory language, they say copy and paste this or else. You copy and paste this or else, and you don't change it. That's the language, even if it's confusing. You can put explanations above and below it or whatever, but you can't tinker with that core language when the statute says include this material. I do think there's some more on that coming up, hopefully. What happens if
I'm going to do one other question before we leave this, because it's about what about, I think this is a pretty straightforward answer, but if a tenant, to voluntarily vacate prior to notice of filing an eviction, do we need to notify them of the right to counsel in a voluntary vacate notice? I think I know the answer, but I'll that one to you.
No, I don't think you have to. I think the right to counsel is really fleshed out in the complaint requirements. So if you're going to file an eviction complaint, I believe that's where you have to present your notice of right to counsel. In your termination notices, I think there may also be some statutory language that hints that way. That has to be there, right, in your termination notices. But this specifically is talking about your complaint. And so your complaint is going to have specific language saying if you can't afford an attorney, yada, yada, yada. That's where that piece is specifically. Your notices will contain different statutorily required language in certain cases. And the truth is, I don't think it harms you to include that in your complaints as a general matter, right? If you have a complaint between a non-payment case or a breach case, and you include language that says that you may be entitled to, an attorney, I don't think it harms you. I think that the templates that I put together, I have a universal, eviction complaint. And I kept that same language. If the judge doesn't want to appoint someone an attorney, well, that's the judge's prerogative. I can't control that process at all. But so long as I've included the magic language, it's going to work for any case that I file, breach or non-payment or otherwise. If you do it in a way that's universally applicable to avoid screwing it up for yourself down the road. So things to think about. You have many different options of how do you want to tackle it. You could tailor it individually to say, this is my non-payment complaint, my breach complaint. I mean, you could specify it out to be much more specific, but that's I think the choice of the practitioners. And what happens if you miss something in your complaint in terms of this required statutory language? Your case is dismissed and you're losing your filing fee. Sua sponte, it is a requirement to the statute. It feels terrible. I've had judges who complained about this. They thought that was wildly unfair, especially for dealing with a mom and pop Section 8 landlord who has one unit they rent. You're going to eat their filing fee. Yep. That is the intent of the statute. It is draconian for a purpose. It is trying to compel you to settle rather than litigate. What happens if your complaint's not clear, or you didn't spell out the facts that give rise to your complaint? It's not notice pleading anymore, right? This is fact pleading. You're pleading your facts in the complaint, which is not a tradition in Minnesota or Wisconsin or really anywhere in the Midwest. You have to be very specific about what you're evicting for and the facts that give rise to the provisions in the lease that are breached. So your case is dismissed, right? It's not well pled enough. It's dead. Case is dismissed. You're losing your filing fee again. But why? Well, again, it's to rebalance the scales. The legislature said, look, we are in charge of setting policy. We are going to rebalance these scales a little bit. And that's their express intent. The truth is, for housers, these provisions specifically, it's a real sticking it to housing providers. There's no other justification for the automatic dismissal. The dismissal after your filing fee has been paid is a real kicker for small time landlords who are going to eat costs that they really can't afford. So that, I want to opine on the wiseness of the law, but the actual impact on your small housing providers who fumble, right? Who aren't hiring an attorney to take their case. They have 1 or 2 units, they're doing it themselves. They're going to fumble. They're going to lose their case. They're going to have their case dismissed, have to file all over again. They're going to eat those filing costs. They're going to eat those service costs. And so for those small fry people, they're going to get caught in the pinch on this. And it's intended to make it harder. It's intended to make it more burdensome, for better or for worse.
Brandon, I was just recently at a CLE talking about this, and this is another one where, like the eviction, where the courts basically said, you know what, this is not your jurisdiction. We're our own branch of government, and we're this is how we manage our records and whatever. And so there was the discussion of that the judiciary might decide, yeah, you can come in here, you can claim that you should get dismissed, but the courts might say the housing authority, you still get the right to cure. And that might be something that the courts decide to do, because like you said, this is a pretty a pretty strident, but again, we don't want any one of our housing authorities to be the test case going forward. Want to help you be able to move forward with your eviction and do it right the first time, so you don't get caught. You don't need to be the test case. We want to help you out on that front.
Yeah, no, and that's a good point to make, actually. So the Minnesota legislature, the Supreme Court, did come down and took a couple of laws that were passed this last session and said, no thanks, we're not doing that, of their own accord. And those were laws telling the courts how they were going to manage their own records or who could have access to what. And so the court does guard very jealously its little bubble of power. And this is right. This could be a case where the courts do kick this, because you're saying, look, you're telling someone they can't come in front of us. We govern the rules of procedure. We govern notice standards. We can accept the changes that you're suggesting to us, but we're really in charge of this area of the law, of the world. It's our little pocket. And if we give it to you, that turns us into a subservient form of government, but we're an equal branch. So it's possible we may see this kicked out, even if not technically by the Supreme Court of Minnesota. You may see lower courts on their own say, you know what, I'm not dismissing this case. And if you don't like it, appeal me. And the truth is, most people will not have the appetite to appeal it, because appeals are incredibly costly and time consuming. So they're simply not going to do it. And so you may, as a matter of fact, see this not go into effect, but you may be in front of a judge who says, I'm going to follow the law as it is, and I'm not going to interject my own thoughts on it. So this is what's happening to you, and it may. So good points to bring up. That goes into effect January 1st, 2024. So make sure you get your notices kind of strapped together for your complaints and your notice terminations in a way that is coherent and can be well understood. And there isn't going to be a question about how they're violating your lease agreement. Something else I wanted to bring up that I didn't initially address that people should be aware of. Oh, I have a message maybe to back up one. Are there any sample notices available? That's a good question. I don't think we have a sample notice available. I think that there was some discussion within NARO to potentially put together some sort of a mocked up template that may or may not be coming. So please don't take that as a guarantee it's coming. I don't speak for NARO on any of that angle, but I heard at one point in time that maybe there's some additional assistance for it on how to grapple with that. It is not hyperly complicated. Certainly, outside counsel could produce one for not a great sum of money, worst case scenario. And you will see, I think, a flood of new templates probably kind of hit the internet as people struggle and fail to meet the standards they need to meet. But I guess that's an outstanding question. I can't promise that I can provide anything without my client's permission and approval on that angle, but we'll maybe look into that some more.
And I'll speak to this. Yeah, I think I would, down the road, I think this still might take some time. And that down the road, if we have some counsel of some of our agencies who are willing to share, but I think we're kind of we're relying on the graciousness of those sources and those attorneys in our field to share those notices. So when I get my hands on it and that permission, I'll be happy to post it to stuff. But at this point, we haven't had anybody willing to share their notices yet, or other elements impacted. So, but if you want to, yeah, agreed that I know that you all would love some samples and leases and other things. I think it's a little early yet to have that out there. But when we do, we will share them. And again, if you have an agency that is willing to share that work product, I think that would be incredibly generous and gracious of you to consider it. So let me know if you're willing.
Wonderful. And then, so we're going to talk lastly here about the redemption ability of people who are subject to filings for non-payment. They're non-payment cases. You have a right to redeem in Minnesota. That basically says, look, yeah, you lost your eviction case, but you get the chance to basically buy back into the property if you pay up the money you owe. And Minnesota passed a statute that says, look, that can be hard to do, right? You have a 7-day redemption period in Minnesota. And so they wrote into the statute that if you are provided a written guarantee from a body of federal, state, or local government, or a nonprofit that administers rental assistance, and it has sufficient money, that notice, that letter you got is as good as cash. You have to, it's redeemed. You cannot proceed. You're done. They've paid you up, even though you just have a piece of paper that should turn into money eventually. I do know that bit about that. The 501c3s that administer rental assistance, if it has sufficient money, we had an issue here in northern Minnesota where it appeared for a short bit of time that we had a nonprofit issuing these letters of guarantee, and there was potentially not enough money in the bucket to cover the guarantees. And we were about to have very, very unfriendly discussions on whether or not they can do that. But luckily, turned out the pot was deep enough to cover it, and so it turned into a non-issue. But please be mindful that you may want to guard against that misuse of this really immense power to basically ice non-payment cases by a letter alone. And if you have some malfeasance or just not, some oversight, lacking oversight in terms of how they're managing that bucket of money when they're issuing these letters, you may find yourself a bag holder who doesn't get paid if there isn't enough money. And you'll have somebody who sat there, in a non-payment case, who will still sit there, and you won't get paid from the tenant or the nonprofit who maybe didn't administer their money the way they were supposed to. So be mindful that that's a change in the law. And just as a general black letter law matter, even without these letters of guarantee out there in the world, their right to redeem generally dies once you get a writ. So they have that 7-day window to redeem, but it really might extend until you get the writ to remove them. So there's some wonkiness on that window as well, to be mindful of that. And that goes into effect January 1st, 2024. We have been just accepting that as the status quo because that's what was going to be the law anyways, and so we were just giving people the benefit of doubt here up in our neck of the woods. Oh, and so we talked about new statutes that were dead in arrival. So Minnesota government access for all lawyers, that is kind of the deep access to the records that government lawyers get. They were going to provide that to all lawyers. The Minnesota Supreme Court said, no thanks, we're not going to do that, no matter what you write into the law or what the governor says. So only government lawyers will have access to MGA. Your government office may be eligible for MGA even if you don't have a law license. I do think they can have attorneys who get into that system. You have to do it, with a great deal of forthrightness and honesty. You do not want to be on the receiving end of an MGA audit that shows that you were looking up records you weren't supposed to look at. So that's something for people to look at to see if they qualify. A second statute that was dead on arrival, the legislature had passed a statute saying that eviction cases are going to be non-public until judgment against the defendant. That would have been a huge game changer for tenants who are under the gun for an eviction case, because they can jump. They can jump and nobody will know that they're about to be evicted until after they've secured new housing. Minnesota court said, look, that's really cool and we appreciate that you feel this way, but these are our records and you shall not tell us who has access to our records. We think that everything should be public to the maximum extent possible because we're a court. And so we are simply not going to do that. And so the court issued an order saying we're just going to ignore the legislature as to these two statutes specifically. So those do not go into effect. And I think some people are hoping that we will see some greater permission slips saying we're just not going to listen to the legislature on the notice requirements for complaints. And we'll see how that goes if that ever shows up. So that's the kind of walkthrough on some of the massive changes we've seen in the law in the world of landlord and tenant law. I welcome any questions in our last 3 minutes if there are any. Understanding, I know there's a great desire for templates and this, that, and I can't promise you anything on that front right now, but that may or may not be forthcoming.
Thank you, Brandon. I don't see anything in the chat box at the moment. That being said, you're ending right on time. So I kind of jotted down three big takeaways. Okay, here, got a quick question here, and then I'll do my recap at the end here. Here's a quick, do you have to have our board approve the updated leases prior to 1/1/24? And again, this would be leases prospectively, most likely. So your thoughts on that?
Yeah, that's a good question. So for most of these provisions that are effective for new leases going forward, I guess for maximum compliance, you would want your lease agreement to be updated prior to that 1/1/24 date, so that way you'd be in immediate compliance. You could, and depending on what goes to the board, depends on what program you're in. Public housing, for example, requires your notice periods and board approval for its leases under the CFRs, I believe. Do you need to? I mean, I guess it comes down to what your personal risk is, right? You can skirt by probably for a while before anybody notices that you're updating your material or a non-compliance, or if it's just a little bit off. So need is a strong word. I can't tell you what you need to do, but you can kind of gauge for yourself in terms of what level of compliance you're comfortable with as you're working towards getting to complete compliance, or if you ever get to complete compliance, depending what your risk tolerance is.
And then another question we have is, I think this is in particular to the reference of the crime-free provisions. Is there a level on the crime of convictions?
Good. That's a great question, actually. Yeah. So if we turn, so if we go here, it's going to be it results in a conviction of a crime of violence against a person unrelated to the premises. That's one of that's your conviction exception. And so there's going to be a list of criminal statutes that links to, and that's going to encompass all of those pieces. I do not think it's going to matter what the sentencing level is for those offenses. If it's one of those statutory offenses, that's what it's going to be. And so you can get because the felony so in Minnesota, the distinction between a felony and a misdemeanor, the gross misdemeanor, it's really like a time gating mechanism. So you can have a gross demeanor offense and be sentenced within the time frame of a misdemeanor, and it's adjudicated to be a misdemeanor by operation of law because that's the criminal penalty you're under. And so in this case, it's really, is it the right statute that you're fighting about that they were convicted for? So were they convicted for and the statute will list out the different types of murder and different types of assault. And if it clicks one of those, I think that's where you are, very clearly within the statute on that question. So when you talk about assault, it's going to link to the entire assault statute and say it's one of these crimes. And regardless of where it sits, I think that it's a crime of violence, even if it's adjudicated to be, a misdemeanor. Keep in mind, of course, that people who unrelated to this, I think, but your petty misdemeanor offenses are not crimes. So just never forget that if you read petty misdemeanor, it's a non-criminal infraction.
Well, thank you again, Brandon. I'm not seeing any more questions. Again, I wanted to just I kind of 3 big takeaway areas or recaps. It is important probably for you all to take a look at your lease with your counsel and think about the various provisions discussed and such, and with your counsel, and if there is any housekeeping to be done there. And then also how that applies to how you want to manage those leases with the new ones going forward that will be impacted by these provisions, and then the ones that you have in existence. So that discussion. I think there's also with your counsel to review your evictions actions and what you need to include, because there's a lot more specificity from the fees you have to include or your non-payment elements, and then you also need to do those addendums if they're impacted of your lease. And then the last area to think about is review your process for unit inspections, particularly with the start and end of a lease, as well as what your process is for repairs and notice around those repairs and the forms that you're going to rely on. So those are 3 big kind of takeaway areas that you might want to consider follow up with your team, and in a couple cases with your counsel. Any thoughts on that, Brandon, before we sign off?
Nope, I think that's a fantastic recap. I encourage people to get into their material and to read the things that they haven't had to read for a long time to figure out whether it still jives with the requirements. And I wish everyone the best of luck trying to drag themselves into the future as we navigate this.
Well, Brandon, thank you again for providing your perspective and expertise. It is greatly appreciated. And I'm sure this won't be the last time. We will probably have an opportunity in next months or so to do another check-in on this, because again, we know that things are going to be working their way through the courts after the implementation of these dates, the effectiveness dates. So thanks so much, everyone. Have a great rest of your week, and look forward to seeing you at our next event with Minnesota NARO. Take care, all.
Thank you, everybody.